Okay, we are streaming. Shannon, you can put us on the record.
Go ahead.
This is a matter of State Treasurer versus Ostapol. Ms. Moody here for the plaintiff, and Mr. Ostapol is here representing himself. This is your motion, Ms. Moody.
Thank you, Your Honor. Susan Moody, Assistant Attorney General, on behalf of the State Treasurer. Your Honor, we're here today on the court's order to show cause dated March 3rd, 2021, why defendant Ostapol should not reimburse the state for his cost of care in a state correctional facility in accordance with the State Correctional Facility Reimbursement Act, otherwise known as SCAFRA, Your Honor. Your Honor, the asset at issue, as we laid out, is Mr. Ostapol's prison account. And the state, that is something that is subject to SCAFRA, and the state is seeking 90% of that asset. The cost of incarceration for up to his earliest release date, which is June 3rd, 2022, is $120,650. Up to his maximum date, it is $595,080, and that the maximum date is March 3rd of 2039. Your Honor, currently, Mr. Ostapol has about a little over $2,300 in his prison account. And that account has been frozen pursuant to the state's ex parte order. And we're seeking 90% of that order as allowed by the SCAFRA action. So I believe we sent the court an order. I don't know if the court has it on hand, just in advance to proposed order, which requires the 90% balance of his prison account. We did indicate in that order, though, that some of the funds were from a stimulus payment in the amount of $600 given to Mr. Ostapol under the CAA. Those funds are exempt, and the state recognizes that. So any order for 90%, we would exclude and exempt that $600, and I believe our order that we proposed to the court does indicate that.
I'm looking at your proposed order now. And yes, it specifically exempts stimulus funds. Mr. Ostapol, is there anything you'd like to say?
Yes, it does say it exempts stimulus money, and then we're all stimulus money checks. So I don't know why they're trying to take my money when the federal government sent it to me, and now the state wants to take it from me. It just makes no sense to me.
My order will only allow them to take funds that are not characterized as stimulus funds.
And Your Honor, can I clarify that? In terms of the stimulus monies, because prisoner did receive, I believe, in March, he received $1,800 as a tax refund. $1,200 of that was pursuant to one act, $600 pursuant to another, and then I'm not quite sure if he received that third stimulus money in the amount of $1,400. It does show a deposit for $1,400 in his prison account, but I can't ascertain if that's a stimulus fund. Nonetheless, Your Honor, it's clear that under the other acts, the $1,200, there's three pieces of legislation for the stimulus money: is the CARES Act, the CAA, and the ARP, the American Rescue Plan. And the CARES Act and the ARP allows creditors to attach those monies. The CAA specifically does not allow attachment for creditors both before and after distribution, but the other two monies, so the $1,200 and if there was a $1,400 that was received, those are subject after distribution to attachment by creditors. So that's why that money, it's not exempt under those specific acts. So that's why we've only exempted the $600 under the CAA.
And I see that. That's what the order provides. So depending on the nature of the stimulus funds, some are exempt and some are not. The ones that are exempt are those that were paid under the Consolidated Appropriations Act of 2021.
Correct.
So, Mr. Ostapo, do you have dependents for whom you are responsible to pay child support?
No, I do not.
All right. Anything else you'd like to say, sir?
Yeah, I was just wondering if they need to take the whole 90% because it was given to me as money to use for myself. And I just don't understand why they need to take the whole 90%. I mean, they're kind of vulturing it. I just don't think that's fair.
I appreciate your sentiment on that, sir. If I were in your position, I would probably feel exactly the same way. But I'm not governed by sentiment. I'm governed by law. And if the law says they can attach it, I really have no basis to deny them the relief that they're requesting. So CAA acts payments are exempt. Everything else is subject to this order. I'm going to sign it and grant it now.
Wow.
All right, we'll see that an order is sent out. Thank you.
Thank you,
That
Your Honor.
concludes our hearing.
Thank you.
You're welcome. Mr. Beer, I brought you in by mistake. I'll put you back. I wish this didn't do this. You click on a name, and by the time it reads it, it's moved to a different name. All right, I believe Mr. Gibson is present. Yes, there he is. And let's see. Council, do either of you expect anyone else on the Gibson versus M&M Core matter?
Well, I don't know if anyone can hear me. I see people are talking, but I have no volume on my end of things. So
Mr. Clevorn, I can hear you. Looks like he's having some trouble with his settings. Mr. Clevorn, can you hear me now? Apparently not. Let me try to get him by phone. Mr. Gibson, can you hear me?
Yes, sir.
Ms. Smith?
Yes, I can hear you, Your Honor.
All right, let me try to raise him by phone.
I've got audio now.
Okay, we can hear you.
Yep. And I can hear everyone else now. I had no audio there for a second, which was strange.
Okay.
I've no idea
So I noticed-
what happened for the first few minutes I was in this, but if you were
Nothing
attempting to talk to me by-
happened. We were just trying to make the connection. I was getting ready to dial your phone number.
Yeah.
So there's two firms listed as counsel for the defendant. Are you expecting anyone from the other firm?
Yeah, so Ross told me that he had an associate planning on appearing today. You know, for the purposes of today, I don't know if he's going to come or not, but I'm prepared to go forward. I mean, it's pretty straightforward on the motion to withdraw. So, but I know Ross himself is not working today, or he's out of the office.
All right. Well, hold on. Let me see if I can figure out who that might be. There was a female associate identified on one of the pleadings, but I don't see her. Let me see by elimination of the people on the only other case I've got at 10 o'clock and see if maybe I can identify. I'll just try them one at a time. Well, this is probably not it. This is the part about Zoom that I don't like, is when it takes forever for somebody to make a connection. There we go. Mr. Horn, what matter are you here on?
The Panhandle Pipeline matter.
Well, I'm glad I checked.
Part about
Okay, I'm going to put you back in the waiting room, sir. Hold on.
right?
All right. Well, he's here early, so let me work my way up. Let's see. Well, you know what? I'm just going to let everybody in. And then I'll just have anybody who's not on this case mute themselves.
Judge LaFlamme, it's Jeff Wells with Kylan Law, and yes, I am representing Eminem.
Oh, okay. Well, good. If everyone else could please mute themselves if you're not on the matter of Gibson versus M&M Core, please. And we will move forward with that case. So we have a motion to withdraw. Ms. Smith, because you've obtained new employment that doesn't allow you to engage in the private practice of law. Is that correct?
That's correct, Your Honor.
So, Mr. Gibson, do you oppose her withdrawal?
I oppose her withdrawal only because I am confident in her ability, but there's nothing I can do about it, Your Honor. She's a great person, and I wish her the best in her future endeavor.
All right. Well, before I let her loose, I do have your supplemental briefs, and I thought maybe we could address that this morning. Is everyone prepared to do that?
I've not had the opportunity to really read Ms. Smith's cases she cited, particularly the unpublished ones in detail at this time. I was expecting mostly to just be on the motion to withdraw. If we want to handle the supplemental brief, we can certainly give it a shot. But I was anticipating, or at least the email I received yesterday said that we'd either get an opinion or a kind of a schedule for oral arguments would be the purpose of today's hearing. But ready to proceed however the court wishes.
All right. Well, I knew this was pending, and if we could get it resolved before Ms. Smith is forced to withdraw, at least Mr. Gibson would have the benefit of whatever remaining arguments she has on this issue.
Your Honor, may I say something? I don't want to withdraw until after you issue an opinion on the motion for summary disposition. I don't think that would be fair to Mr. Gibson at all. I just wanted to get this motion heard, since I'm not going to be able to have much free time after the 21st, and I wanted the hearing before then. So, but I certainly would never leave him in that position. And to be honest with you, I made so many points in the reply brief, which I didn't get a chance to look over today because I didn't know we were going to discuss it. I'd ask for another date to be set, to be fair to Mr. Gibson, so I can make a detailed argument about it.
Okay, and does next Friday work for everyone?
Yeah, that works.
All right, and I will be granting the motion to withdraw, but it just made sense to me that if we could tie up the issues on that outstanding motion, that we do so. So let's do that. Let me just double check and verify that my calendar looks reasonably manageable next Friday.
That would be Friday the 18th.
Yes.
Would it be at, I guess we're gonna look at the time.
Yeah, I think I could certainly accommodate you next Friday. Does that work for everyone?
Yes, that worked for me, Your Honor.
That's available on my calendar as well, Your Honor.
Would it be
Right,
at 10 o'clock as well?
Well, I'm just trying to see. Why don't we set it at 9:30? Let's do it at 9:30. Shannon, can you put that on the record?
Yep.
Or on the
Just so they know, I'm just gonna put it on. They're not gonna get a notice.
Yeah, you're not gonna get a notice. Just mark your calendars. I'll look for you. I'll look for you next Friday.
Okay.
Thank you.
Okay, great.
Sounds like a plan, Your Honor. Thank you very much.
You're welcome.
Your Honor.
See you then.
Thank you, Your Honor. Have a good afternoon.
You're welcome. You too. So we're going to want to hold on to this file. I'll just take it back onto my desk. Okay, I think we are ready for Great Lakes Home Health versus Ewing et al. I know there's some folks present who aren't on that case, but those of you who are, if you could state your appearance. Bless you.
Bless you.
Good morning, Your Honor. I'm Thomas Davis for Great Lakes.
Morning, Your Honor. Brendan Beer for the defendants.
Morning, Your Honor. Kevin O'Shea on behalf of Ms. Fury.
Okay, so we're here on plaintiff's motion. Go ahead, counsel.
Thank you, Your Honor. As the court knows from the last time we were before you, Ms. Sherry Lynn Derry, who is the witness in question here, was a key witness in inducing the breach that underlies the tortious interference portion of our case. And as the court knows, she
If
is,
that's true, why didn't you sue her?
because, Your Honor, she's an agent of Caroline, who is the defendant. So Caroline can only act through agents, and we believe that she's an agent of Caroline for the reasons we set forth in our brief. So as we set forth, she directly communicated with the individual defendants in this case in order to get them hired to work for Caroline. And so obviously, given that she was an agent of Caroline involved in the tortious interference, she's a key witness. She's put up obstacles and barriers to our getting that testimony and getting documents from her in this case and in a related case. And the last attempt was the motion that was before Your Honor a few weeks ago. She tried to severely restrict the questions that we could ask at deposition and tried to restrict the document requests that we had made. And the court largely denied the relief she requested. The court said on the testimony, we're just going to follow the court rules. And on the single document request at issue, the court said that the scope would be that documents related in any way to defendants would be relevant. What happened here, and which we believe crossed the line with the obstruction, is that her counsel submitted an order, admittedly without telling us, that inaccurately portrays what the court's order was. And we've provided the court with the transcript of the hearing, and the differences are clear. As I said, the court held that we're going to follow the court rules on testimony. If they're far afield or fishing, you can instruct your witness not to answer, and the court will then resolve that issue. That's at page 6 of the transcript, which is Exhibit 4, I believe. If you look at the order that they submitted without telling us, basically they give themselves the unilateral ability to decide that a question is irrelevant and then instruct the witness not to answer, and that's what they did several times at the hearing. The same thing with the documents. The court specifically said that any documents that are related in any way to the defendants will be relevant. And that's at page 13 of the transcript. The order they submitted in secret without telling us says that the scope is limited to any documents that were received or provided by the defendants. Completely different from what the court had ordered. So based on this surreptitious order that was entered, Ms. Deary was instructed not to answer questions on obviously relevant topics. And the one example that I want to go into is this Dem Holdings. We have documentation showing that her solicitation was done with an email address that was SherryLynn.Deary@demholdings.com. That's the same email account address that Caroline's CEO and her son-in-law uses. And we know, because we have the documents from the individual defendants, that she was doing business for Caroline using that Dem Holdings email account. So when we asked her questions about that at the deposition, her counsel just said unilaterally, Dem Holdings is irrelevant. We made an offer of proof. Look, she's using Dem Holdings emails to engage in the conduct that we say is the tortious interference in part. And he says, no, I'm still going to instruct her not to answer. On evasive answers, I think it's, it just pops out of the transcript. We've given the court the transcript, but I think the first example just goes to show how evasive and misleading Ms. Deary's answers were. When she was asked, do you work at Caroline, present tense? Her answer very quickly, no. Did you work at Caroline at any point in the past? Same question, past tense. All of a sudden, she has no idea what the questioner means. Could you explain what that means? And you see in the brief, we have a page or so where she's just giving evasive and answers and nonsense statements that she didn't understand the questions. So it's very clear that she had no intention of giving complete, honest, and truthful answers at the deposition, and we believe that she should be made to do so. Now, on the document request, she's admitted she didn't search several of the categories of documents that are in the subpoena, and that the court did not grant their motion on. Instead, what they did, and they've said now in their brief, what they did is they made another unilateral determination. We don't think these documents are relevant. They're responsive, but we don't think they're relevant, so we're not going to produce them. And that's a little bit different from what Deary said, which is that she just didn't search at all. And again, we know documents exist. Again, we have bits and pieces from the recipients of some of her emails. And obviously, Derry, when she's searching her emails, those should have come up in the search. And it's reasonable to expect there will be other emails than the few that a few recipients had in their mailboxes. So she hasn't done the searches. She hasn't given testimony for the court's order. And we believe that, given the circumstances here, this is really a contempt. Sanctions are warranted, but at a minimum, she should be required to come back, testify, provide the documents, and you should have to pay for the attorney's fees for that second hearing. Unless the court has any questions.
Thank you.
Nothing further on the motion. Thank you.
Your Honor,
Mr. O'Shea?
Your Honor, I think the request for sanctions, first of all, is just a terrible overreach under these circumstances. I think what's happened here is that plaintiffs have clearly been after Ms. Deary in one way or another for many months. They've tried suing her unsuccessfully. I think your question about why she was brought in goes right to the heart of the issue here. And Mr. Davis's comment that she's now an agent, supposedly, of one or more of the defendants is news to me. It's not something that's alleged in the complaint. It's not something that they've ever offered any evidence or allegation on before. She's not an agent. She's a non-party. They call her a non-party themselves in their motion. That's her status here. With regard to this order that was entered, and that was our error, Your Honor. There's no nefarious plot here to surreptitiously get an order entered. That was a mistake here from our office, and we take responsibility for it. But it has no bearing here because at the time of Ms. Deary's deposition, nobody, including counsel, was aware that any order had been entered. We proceeded with the deposition as if no order had been entered. And yes, I did instruct Ms. Deary not to answer questions regarding DEM holdings. And I think Mr. Beer's submission to the court this week clarifies exactly why. The plaintiffs are confused about these DEM holdings entities, and there's no reason for them to be confused because they've deposed Mr. Mead, they've deposed others who have clarified exactly what DEM holdings entities are, and that the one involving Ms. Deary has no connection at all to the defendants. They have no connection between her and the defendants. And therefore, questions about her business dealings that are irrelevant to the claims are off limits. There's no reason why they get to go pawing through her financial life simply because they think there might be something out there. We cited case law in our brief indicating that the test is whether, in the case of a party even, not even a non-party, whether the allegations or the questions go beyond conjecture. And that's exactly what you've got here, Your Honor, just pure conjecture on the part of plaintiffs that she has some connection. There's no evidence of that. And as I indicated, Mr. Beer has made that clear, and I think he'll be able to clarify that even more in a moment. The real question here is whether Ms. Deary was evasive or non-responsive. The only time she was non-responsive is when I instructed her not to respond, and I defend that.
Let me stop you for just a minute. Mr. Beer, is Mr. Lindsay participating in this? I saw him sign in. Should I bring him in?
He's co-counsel on the case. I didn't know if he was going to sign in or not, but if he's on this,
right.
Yes.
He just appeared, so I'll let him in. I didn't see him anywhere else on the docket, so.
Okay.
So, Mr. Shea, with respect to Ms. Deary's testimony, I got to tell you, what I read sounded a whole lot like Bill Clinton's answers in a famous deposition that he was given. It sure looked to me like she was playing games.
Well, Your Honor, I was there. I didn't think she was playing games. And I think what they've cited in their brief is simply she was asking for clarification of the meaning of certain statements. And in light of what's been happening in the months up until her deposition, including other depositions by plaintiffs, I don't think she can be blamed for trying to put the plaintiff's counsel through his paces to make sure that he is asking only about connections between her and the defendants, rather than trying to find through a fishing expedition information about her other financial dealings that have nothing to do with the case.
Well, the impression I had was they were asking about communications relating to an entity in which she has an email address in their domain name, and that entity itself was in fact connected in some way to the defendants. Did I get that wrong?
Unfortunately, you did get that wrong, Your Honor. There are two DEM Holdings entities, and I think that's what accounts for the confusion. I would have liked to clear it up, but I didn't feel that I could quote from Mr. Mead's transcript as a non-party, given the fact that there are protective orders in place. Mr. Beer, I think, very carefully explained in his submission what the difference is between the entities. And the DEM Holdings entity they're asking Ms. Deary about has no connection with any of the defendants. And she testified very clearly, she doesn't work for the defendants, that any services she provides for the defendants are merely incidental because she happens to be related to one of the owners of the enterprise. She came prepared to spend an entire day answering questions. Plaintiffs determined that they didn't want to ask her any more questions, that they didn't want to introduce exhibits that they now claim show some kind of connection. There is no such connection. And I'd respectfully suggest, Your Honor, that if that's all we're trying to determine is whether this DEM Holdings entity of Ms. Deary's has any connection to the defendants, that plaintiffs be required to submit written deposition questions to clarify that specific issue. And Ms. Deary will be very happy to respond. But you can understand her frustration at being asked to repeatedly appear for depositions where she's being asked about her financial dealings that have no connection at all with the case.
Your Honor, could I please respond to that briefly? I think it'll cut
Sure.
through some of this. So, and part of this, it's probably deja vu because your court heard these arguments last time when it rejected it. This has it completely backwards. We have explained, and your Honor was correct. First of all, the DEM Holdings that Joe Mead claims is completely different than the one his mother-in-law works for. They both have the exact same email address, which means that they have one email server and they're both jointly using it. At a minimum, we're allowed to inquire into that. And she's required to search her DEM Holdings email account for documents related to this case, which she did not do. Second, the court said that this was going to proceed by the court rules. Well, how do the court rules address this? An attorney doesn't get to just state in advance, look, you're wrong about your case. We don't think it's relevant, so we're not going to give testimony. That's backwards. We're entitled to ask questions and learn the facts and inquire into the facts. We don't have to take the word of the attorney for the witness that it's not relevant. So we have a case, again, Your Honor will remember that Sherry Lynn Derry emailed and communicated with the individual defendants, Stump and Ewing, about joining Caroline, which would have been in breach of their contracts, which she was aware of. We have calendar entries where Stump and Ewing are saying they're going to have a meeting at the DEM offices with Derry. I mean, DEM is involved in this and Derry's involved in this. Now they say, well, she's not an agent. We're entitled to test that. We believe she was working on Caroline's behalf because she was communicating directly with two people who jumped over to Caroline and started working for them. She was communicating with them to jump over to St. Croix, another entity she's involved with, and they started working there in breach of their agreements. So Sherry Lynn Derry's involvement and whether she's an agent is a critical issue in the case, and we're entitled to inquire into that. So I think that really just underscores the evasiveness and the failure to obey the court rules that occurred at this deposition. And we would ask your Honor to allow us to go back in, do the deposition properly with Ms. Derry under court order to stop the games and allow this deposition to happen. Whether she doesn't like it, doesn't want to play by the rules, is upset that she's being brought into it, that's not, and again, relevant under the court rules. We have a reason in this case to ask her those questions, and we should be entitled to do so. Thank you, Your Honor.
Your Honor,
Mr.
Ms.
Beer?
Deary, I'm sorry, Your Honor, I just wanted to say one more thing. Ms. Deary did not refuse to answer any questions regarding her connections to the defendants. She answered those questions. She answered them clearly. The issue here is whether the DEM Holdings entity that she is involved in that has no connection to the defendants is fair game for discovery. And second, whether she produced the documents she was required to. And she testified that she searched for any documents related to the defendants that she had received from the defendants or that she had transmitted to the defendants regarding the plaintiffs. And she produced what she found, which was very little. They already have the communications between Ms. Deary and the defendants. They've asked for those documents and they've said in their briefs they've received those from defendants, which is entirely proper. There isn't anything she has that isn't duplicative of what they already have.
And Your Honor, again, if that is true, it's not a proper objection to document requests to say, well, you've already received them from another source. We don't have to produce them, because that's, first of all, that's not the law. But there's reason to believe that there's going to be other documents where maybe she wasn't talking directly to the defendants, to the individual defendants, but she was discussing the solicitation with Meade or somebody else. She's talking about the case and she's required to do the search. And the fact that they didn't produce any documents that we know should have been produced is consistent with her testimony that she just didn't search for Dem Holdings because she made the determination that that's completely irrelevant. We're not allowed to ask, and she's not going to do the search. So she should be required to do the searches based on what is responsive to what is in our subpoena and not based on her own determination as to what's relevant. And that's clearly what's happened here. They decided what is and what is not relevant and did or did not do searches and productions based on that unilateral determination.
Mr. Beer?
Your Honor, I mean, I guess I'll start out by saying that when you listen to these two arguments, you'll understand completely what my frustration has become about this case. I represent just the defendants, not Ms. Deary, not the plaintiffs, and I've come to this hearing because there's not, and I mean, Ms. Deary is not a party. Neither of these DEM entities is a party. My clients, Carolyn Ewing and Casey Stump, did not come to work for Caroline. Just so you know, Your Honor, one of them was actually fired by the plaintiffs. And the other had been gone from the plaintiffs for more than a year before she came to work at Caroline. I mean, there was an extensive period of time between when these two females, who are just low-level administrative employees, frankly, not executives, not salespeople, nothing, but for some reason have a covenant, left, and more than a year later, they joined Caroline. And now we're having these arguments about DEM Holdings Michigan versus DEM Holdings Group, because this case has become about nothing that has anything to do with the defendants, but an extension of what, I got to be honest with you, has been a multi-years long attempt on the part of the plaintiffs to try to blame whatever issues they're dealing with on Ms. Deary, who hasn't, based on the briefs they submitted, had a non-compete or a covenant of any kind with them for more than 2 years. My concern is that my clients are being forced to expend time and effort and money to attend hearings and depositions that have almost nothing to do with anyone who's a party in this case. Questions about DEM Holdings Group that have already been answered by Mr. Meade. We've provided corporate records, operating agreements, tax returns, everything that they've asked for so that they can get into the ownership of these Caroline entities, mostly because they just wanted to know whether Mrs. Deary was involved. Because at the end of the day, whether Ms. Ewing and Ms. Stump have violated any restricted covenants that may or may not be at issue in this case, it doesn't matter who owns these entities. I could own them. It makes no difference who the owner of these entities is as to the outcome of the case. It has nothing to do with what these defendants did for Alara, what they did at St. Croix, or what they're doing for Caroline today. It doesn't matter if I own it, you own it, Bill Gates owns it, Mr. O'Shea owns it, but it makes no difference whatsoever to the outcome of the case. And so the question becomes, how does anything Mrs. Deary has done have to do with what Carolyn Ewing and Casey Stump have done? There has been no testimony in these cases that she works for the Caroline entities, none. She's testified, I do not work there. Joe Meade has testified, she's not an employee. She's my mother-in-law. She comes, she goes, some days she's there, some days she's in Florida. I have no say over what she does. She has no role. She comes in and helps us out here and there, especially during the pandemic when we were doing testing. That's the testimony, and they've asked about it 600 times. They just don't like the answers, so they keep taking dep after dep, multiple deps of each person in the case by utilizing the corporate deposition report rules. I mean, these questions have been ferreted out. We've spent an insane amount of time on a covenant case in discovery. I mean, crazy amounts of time. no injunctive relief requests in this case, year and a half into it, just dep after dep. I've spent the whole month of May in deps. It's the amount of discovery we've produced, seriously, thousands of pages of documents and emails, all in a restricted covenant case for 2 women, neither one of which held an executive role at Alera ever during their employment. It's crazy because I got to tell you, I have a long experience with Alera and these non-competes. Everybody from the janitor to the CEO signs one. They use them as chains, not as anything to protect their business. And then they just sue you because they like the impression of litigation because it keeps people around instead of just treating them well and paying them. But my clients have been sucked into a inferno of litigation that just, it's become very clear, has little to do with anything they're doing.
What's Mr. Beer?
Yes.
What's your theory as to why they're so interested in finding out about what involvement Ms. Deary had? If it's not
I think they want to sue Ms. Deary, and I think that, which they've already done unsuccessfully once. They sued her in the Eastern District over her involvement supposedly with Caroline, had no facts to support it in their complaint, and as a result, it was dismissed. They went purely based on conjecture. The court dismissed it. They ended up at the 6th Circuit Court of Appeals, realized they were going to lose and withdrew their appeal. Now they've used these cases as, frankly, an attempt to try to garner more evidence so they can resue her. I don't think any of these have anything to do with the defendants. Otherwise, it wouldn't matter. I mean, if you had an employee who left to go to your competitor, who do you care who owns the competitor? You don't care. All you want to do is stop them from violating the covenant. It doesn't matter who owns it. It could be publicly traded. It could be whatever. Who cares? These issues have nothing to do with whether or not Ms. Ewing and Ms. Stump have violated restricted covenants. None. And so we're caught up in this fishing expedition between Ms. Deary, and I've laid out DEM's Michigan DEM Holdings Group. They have, because we wanted to try to kill this issue without incurring hundreds of thousands of dollars in legal fees. We've given them all kinds of information about everything that exists about the ownership structure of DEM Holdings Group, LLC, which is the single member that owns Caroline Holdco, which owns all the Caroline subsidiaries. They've asked who those subsidiaries are. We've testified as to that. They asked what her role was there. We told her. She has no role. She's my mother-in-law. She shows up when she wants to. She doesn't when she doesn't want to. And I say, hey, how you doing? People see her in the hall once in a while. She steps in and helps out when she has time. We don't know if she's going to be there the next day or the next month. It could be, and that's been the testimony. They don't like the answers, so they just keep driving and driving and driving. And in the meantime, my clients are just along for the ride. And to me, if they have issues with Ms. Deary, they need to take them up with Ms. Deary. I don't understand why this case is being used to explore that endeavor at all. Because even frankly, if Ms. Deary did solicit these people, which the testimony does not support, even if she did, it doesn't matter to this case. That matters to some case involving Ms. Deary, if there's anything out there. It makes no difference.
If she did it on behalf of one of the defendants,
which there's no evidence of at all. These two plaintiffs were gone for, these two defendants were gone. But
isn't that what he's trying to discover? Is whether or not she did such a thing on behalf of the defendants, knowing that these two people had covenants not to compete, and solicited them in violation of solicited them to breach their non-compete agreements. I mean, that is a tort.
Here's what I would say to that, Your Honor. First of all, they have asked Ms. Ewing directly, how did you come to work at Caroline? 2 different times. She's answered it. They didn't like the answers because it didn't have anything to do with Ms. Deary. They asked Mrs. Stump, same questions all throughout her deposition. Didn't like the answers. They actually asked Mrs. Deary about these issues during her deposition. She didn't refuse to answer any of those questions. She answered them all. They didn't like the answers. The only question she was instructed not to answer had to do with this DEM issue. They could have asked her, we have exchanged thousands and thousands and thousands and thousands of pages in emails. None of those emails were introduced as exhibits during her deposition. because the game is not to get answers. The game is just to jerk her around and drag these things out and cause as much havoc for her and, frankly, my clients as they can. All these emails that they said they have that tie her in, DEM, you know what wasn't an exhibit of her job? A single email to her from DEM. I mean, I sat through that thing, didn't ask a single question, and thought, what am I doing here? It's just.
And if I may, Your Honor, we wouldn't be here if Sherry Lynn Derry had given truthful, non-evasive answers of the deposition and searched for the documents that the court said that she had to search for when it rejected her motion. We would not be here, and this would be over if she had just followed the court rules and done the searches that the court ordered. And again, this whole, the whole argument again from Mr. Beer, in what other universe would a party not be able to ask the direct party who we believe was the agent who induced the question? Well, some other witness already answered and you didn't like it. That's not the standard. We're entitled to ask her, and we're entitled to have her search her documents, because the one thing we can say is that while she's, does say she doesn't recall or doesn't understand questions a lot, when there's documents, it's hard for her to, it's hard for her to deny the written word, and she doesn't want to search the documents either. This is really a case of she's protesting too much. This could already be over, and it really just suggests that she has something to hide here. So, Your Honor, frankly, all these arguments were already brought up to the court before. The court made its ruling, and this is a second bite at the apple in derogation of what the court ordered the first time. So I really think the court should grant our motion, require her to show up, and require her to pay the fees, because, as Your Honor said, she was playing games. Thank you.
Well, Your Honor, I take exception to the notion that Ms. Deary gave any untruthful answers at her deposition. That's the first time I'm hearing that. Until now, it's just been evasive and non-responsive, which I disagree with as well. But I think Mr. Beer makes an excellent point when he notes that there were no questions at her deposition going to what Your Honor just talked about. Was she working as an agent of Caroline in soliciting Ms. Stump and Ms. Ewing? There was no question in that regard. She would have answered that question very clearly. That's not what they were getting at the deposition. And I'm looking right now in my office, I'm looking at 2 banker's boxes full of exhibits that I got the night before the deposition that were purportedly going to be used at the deposition. And fewer than, I think, a half a dozen were even introduced when they decided to cut off the deposition halfway through the day. I think Ms. Deary is perfectly justified in having a concern that they're asking her questions about her business dealings and financial affairs that have no connection to the case. She's not required to answer those questions. They are not relevant. And I would indicate that if they've already gotten the information from other defendants or in other means, it's not proportional either. And it's not required under the court rules. She is a non-party here. She should not be required to open the doors to all of her financial affairs because they want to go fishing.
All right. Thank you, gentlemen. So with respect to the order that was entered, I don't know why I even signed such an order, but unfortunately, when I get a huge stack of orders to sign, I'm not always careful to see, does it have the little stamp at the top that says it was submitted under the 7-day rule and the period for filing objections is passed, and therefore it's okay to sign it. I never should have signed that order in the manner that it was presented. That was my error. So let's talk about what should be the correct order. And I believe I saw a proposed order attached to the plaintiff's motion. Is there any, yeah, I see it. Is there any argument that this order does not, in fact, reflect my ruling on this issue?
Your Honor, it was my understanding that, and I went back and looked at the transcript, that when you ordered that Ms. Deary only had to produce documents that she had received regarding Alara or received from defendants or given to defendants regarding the plaintiffs, that applied generally to the subpoena. If I was mistaken about that, I apologize, and I'll certainly stand by whatever the court intended. to state with regard to the documents.
If she's got Dem holding documents or communications that pertain to the defendants, she should have to produce those.
I agree, Your Honor. There are no such documents. You know, she'll certainly, I don't know what, we just went through a whole explanation about how the Dem Holdings entity that she is involved in has no connection to the defendants. It's the other Dem Holdings that Mr. Mead operates that connects to the defendants.
But two entities that use the same email domain. I mean, there's obviously some connection between those entities.
Just
right. I'm not saying that there isn't an email connection between entities, just that her entity has no connection to the business of the defendants. It's an unfortunate confusion regarding the email. I will certainly instruct Ms. Deary to conduct a search of her DEM Holdings emails regarding what the court thinks she should specifically look for. Because I'm confident she's not going to find anything.
Well, and Your Honor, again, I mean, just to go back, I just want to be clear, because the court's order, again, we're hearing something different from the defendants than from what the court ordered. Again, the court said, and I'm quoting, this is page 13, I'm going to limit, if she has a lot of documents that she received from the defendants, that's certainly going to be relevant. If she has a lot of documents that are related in any way to the defendants, that's fair game for inquiry. And then you said, but if she has a lot of documents from another source that have nothing to do with the defendants, I'm not going to allow that. The defendants here, Caroline, Care Evolutions, Stump, Ewing. Any documents from Dem Holdings email account that relates to those four defendants is part of the court's order from the first hearing. And again, we're hearing this artificial limitation that it had to be to and from the defendants. No, she could be discussing it with somebody else at Dem Holdings. Didn't have to go to Stump and Ewing, but it's still relevant to the case if she's talking about Caroline, which we believe she's an agent of, or Stump and Ewing, who are the other defendants, or Care Evolutions, the third defendant. So, you know, I believe our order, if you look at it, Your Honor, look at the transcript and look at our order, it tracks exactly what the court's words were. And that's the order that should be entered. And on all the topics for the document searches, it's very clear, and we pointed out her testimony again, she didn't search Dem Holdings, she didn't search for documents related to St. Croix, who she also solicited Stump and Ewing to work for in connection with the same transactions here. And she didn't search for anything about the hospice company that we mentioned in there. So there's just a lot of material that would have been responsive that she just failed to search for at all. And I want to just make clear that when the order comes out, it's not going to be artificially limited again, as if Miss Deary won the motion last time, which she didn't. It should follow the court's language and order from the first hearing, which unfortunately the fact that they didn't follow it is why we're here again today. I don't want to be before the court a third time on this, Your Honor.
All right, I am going to sign the substitute order. Ms. Deary absolutely needs to search her documents, search her email to find the documents that are responsive to the subpoena, if there are any, and produce them. And she may be deposed concerning those issues. And if I see the kind of answers that are exemplified in the excerpts that were given to me again, I absolutely may hold her in contempt. I'm telling you, it sounded like Bill Clinton's answers to me. Tell me what depends on what the definition of is. I expect more responsive answers than that. I don't want to see any gamesmanship. If I see that, there could be consequences. So I'm signing the substitute order.
Your Honor, may I clarify one thing? So is the sequence that Ms. Deary will conduct the search, produce the documents, and then the plaintiffs will, depending on what she produces, notice her deposition again? If she finds no documents, is she to be deposed again?
I'm not going to limit whether or not there's a choice to redepose her. I understand why the frustration and why the deposition was ended prematurely. But I'm going to leave it to Mr. Davis to decide whether or not he wants to redepose her.
And Your Honor, just so I can clarify, because some of the evasive answers, there were evasive answers about questions as simple as past tense. Did you used to work at Caroline? And you saw that. So I just don't want there to be any suggestion that, as Mr. O'Shea suggested just now, that it has to only be related to the documents, because her evasive answers were far beyond just not searching.
I'm not limiting the scope of the deposition any more than I did previously. I'm simply making it clear. I saw definite indications on Ms. Deary's part of evasiveness, particularly on simple phrases and simple terms. I don't want to see that again. So instruct your client accordingly, Mr. O'Shea.
Understood, Your Honor.
Thank you, Your Honor.
All right, we'll be sending out that amended order. Thank you, gentlemen.
Thank you, sir.
Thank you, Your Honor.
So would you put a date stamp here and here so I can get entered down? Yeah, that's for a date.
Okay.
Okay, let's see. I got a pretrial left, I think. Panhandle Eastern. No. Oh, it is a pretrial. Yes, you can take us off the record. Let me stop the live stream.